What the judge said next left the entire courtroom in silence. A 120-day deadline for filing a written statement can be explained beyond that period, rules Andhra Pradesh High Court. The High Court ruled that a delay in filing a written statement within 120 days can be explained beyond that period. The requirement to furnish reasons for delay is procedural in nature and cannot be applied in a manner that defeats the right to defend. The court clarified that the written statement filed after 30 days but within 120 days must accompany the prayer to condone the delay, or the reasons may be stated in the written statement itself. The requirement to furnish reasons for delay is procedural in nature and cannot be applied in a manner that defeats the right to defend. The Andhra Pradesh High Court has ruled that a defendant can explain delays beyond the 120-day deadline for filing a written statement as long as the reasons are provided. This decision comes after a division bench of Justice Ravi, Nath, Tilhari and Justice Maheswara, Kuncheam examined the Commercial Courts Act and its applicability to commercial disputes. In this case, the defendant received a summons but filed its written statement beyond the initial period of 30 days but within the outer limit of 120 days. The plaintiff applied for the striking off of the written statement on the ground that no application for condonation of delay had been filed along with the written statement, nor were reasons for delay stated. The trial court accepted this contention and struck off the written statement, holding that compliance with procedural requirements under Order VIII Rule 1 CPC, as amended for commercial courts, was mandatory. However, the defendant challenged this order, contending that the written statement having been filed within 120 days, procedural lapses should not defeat substantive rights and that an opportunity ought to have been granted to explain the delay. The High Court examined the scheme of Order VIII Rule 1 CPC as applicable to commercial disputes and reiterated that while the provision prescribes strict timelines, its nature remains procedural. The court clarified that although the court is required to record reasons while accepting a written statement filed beyond 30 days but within 120 days, such a requirement presupposes that reasons are placed before the court by the defendant. The High Court observed that the written statement filed after 30 days but within 120 days must accompany the prayer to condone the delay, or the reasons may be stated in the written statement itself at the same time. The court rejected the rigid interpretation adopted by the trial court and held that the absence of such an application at the time of filing does not permanently foreclose the defendant's right. Was this verdict fair, or did the judge go too far? Tell us in the comments yes or no.
Here's what this means for you. If you're facing a commercial dispute, know that you can explain delays beyond the 120-day deadline for filing a written statement. Ensure you provide sufficient cause and file an appropriate application with the court. Save this video for future reference.
Follow Legal Output on Instagram and Legal Output Official on YouTube for daily legal updates.